Okay, so what are we going to talk about today? Solo and small practice compliance issues. The federal government has several tools in its toolbox to combat fraud. Among those are the Stark Act, the Anti-Kickback Statute, and Florida Patient Self-Referral Act. Each of these typically focus on a particular type of behavior that is prone to abuse by healthcare providers. They predict as more quality-based requirements are implemented, government oversight of the healthcare industry will increase. This means more audits and investigations on healthcare providers and their practices. I think that's all done with the thought in mind that it lowers everybody's healthcare costs. So today's presentation by the healthcare law firm will focus on compliance, exceptions, and pitfalls associated with the Healthcare Clinical Act, Stark Law, Anti-Kickback Statute, Florida Patient Self-Referral Act, and the HIPAA versus FIPA. I'll be corrected soon enough if I got that wrong, FIPA. So we have two attorneys at law from the healthcare law firm, Christopher Brown, Lance Leader. Will you guys please come on up here as we recognize them? Christopher Brown has practiced healthcare law on an exclusive basis since graduating from Barry University School of Law in May 2009. He represents physicians, dentists, nurses, pharmacists, massage therapists, and other healthcare providers. His practice encompasses both health law and administrative law. Welcome, Christopher Brown.
Thank you.
And Lance Leader, as a healthcare attorney, Lance represents healthcare providers finding themselves the targets of investigations in state and federal cases. These cases include fraud accusations, licensing and disciplinary issues, administrative hearings and appeals, regulatory matters, and litigation. And with that, welcome, Lance. Everybody ready to get started? I am. Please, gentlemen, it's all yours.
Thank you. That was quite the introduction. We'll try to live up to expectations here. So today we are going to be talking about compliance issues that we see in our everyday practice. And specifically, we're going to be dealing with the Healthcare Clinic Act, the Stark Law, the Anti-Kickback Statute, Florida Self-Referral Act, which we call Baby Stark, and the Florida Patient Brokering Act. And then Lance is going to go into some of the issues related to HIPAA versus FIPA, FIPA being Florida's version of the HIPAA law. So to start with the Healthcare Clinic Act. The Healthcare Clinic Act was designed to require non-healthcare provider owners of healthcare entities to have the clinic license through the Agency for Healthcare Administration. This act was established in 2003, and the purpose was to add added restrictions to non-physician owners. We deal with this on a daily basis, and I can say that it is a very onerous application process. It's very difficult to get a healthcare clinic license, and there are some very specific requirements that are placed on non-physician owners of healthcare practices. One thing that's very important to note is that if any portion of the business is owned by a non-exempt person, then it is in violation of the Healthcare Clinic Act. You have to have a license. So what are some exemptions? The obvious ones are allopathic physicians, osteopathic physicians, but it also applies to chiropractors, podiatrists, optometrists, dentists, nurse practitioners, and other providers that are licensed under Chapter 464 Florida statutes. The requirements for a healthcare clinic license from the Agency for Healthcare Administration are that you have to provide proof of financial ability to operate, background screenings, which include screening of the director and chief financial officer, disclosures of certain additional information, and you have to have a medical director. This medical director must be an allopathic physician or an osteopathic physician. The medical director duties ensure that medical professionals are properly licensed and certified. They ensure that record keeping compliance is taken care of. They report non-compliance, and they review the clinic for possible fraud.
One other thing with the medical director, a lot of clinics have medical directors, but a lot of people forget that it has to be in a written contract. So you have to have a written contract with your medical director, And the contract has to spell out that each one of these items here listed are the actual duties that the medical director. So it's not just somebody who comes in once a month and does a chart review or signs off or something like that. They actually have to personally pull the licenses of all of the people and make sure that they're compliant. And all of that goes back to their professional license. So they're subject to discipline for not complying.
And I think it's under, what is it, Chapter 400, Section 990 through 995. There are specific requirements for the medical director. So if you are in the position where you have a healthcare clinic and you're going to have a medical director in place, what we do at least is we take those requirements that are under the statute and put them into the medical director agreement. So some traps for the unwary. If a non-exempt person owns the clinic, practice, or facility, it's illegal. If a non-physician controls all major decision-making for the clinic, the practice, or the facility, it's illegal. If the financial matters are controlled by non-physicians, or if a corporation or limited liability company owns the clinic, then it's also illegal. So what are some real-life scenarios? And these are things that we have seen, and we've read cases that involve these specific facts. Scenario one is that a physician practices medicine through a limited liability company, which the physician owns with his non-licensed wife. Right now, you have a compliant situation. This is permissible under Florida law. The physician dies, and his wife remains the sole owner of the practice, and she hires a locum tenens physician to come in and treat patients. So what happens when the physician dies, and all of a sudden you have an LLC that is solely owned by a non-physician? As of the date of death of the physician, the practice is operating illegally. So each day of operation is a separate felony as well. So you need to be very cognizant of whether or not there is a violation taking place. A second scenario is a physician is licensed in Florida and operates a medical practice under a sole proprietorship. The physician desires to reward her practice manager, a non-licensed business person, by making him a partner in her practice. The practice continues to operate as before without a healthcare clinic license. This is something that we see quite frequently. So the clinic is still owned by a physician, but at this point the physician has brought in a non-physician owner, someone that has a membership interest in that practice. As of the date that they brought in that new partner, that non-physician, the practice is operating illegally. Third scenario, a physician licensed in Florida decides to sell the practice or decides to retire. Three non-licensed business people decide to form a corporation to purchase and operate the practice. The corporation purchases the medical practice's assets, including patient records. The corporation has not applied for or received a healthcare clinic license. As with the other situations, you now have non-physician owners. On the day of the closing, the practice is operating illegally.
Another really similar scenario to that is we have a physician who just gets tired of the day-to-day business operations, doesn't want to deal with wants to just treat patients basically. That's what they went to school for, and they get involved and they get kind of disillusioned. And so you have a lot of these management companies who will come in and they will offer to basically do everything for the physician, and all they have to do is show up and treat the patient. So that sounds great. So they go to sell their practice to this management company, and that's basically the same thing. So you can have a transfer of ownership. The physician, everything stays the same. There's a seamless transition from one day to the next, but now you have a corporate practice of medicine scenario which requires a clinic license.
So some of the consequences of violating the Healthcare Clinic Act, it's a third degree felony for each day of operation. So some of those scenarios that we talked about where you have a non-physician owner that comes in, we'll take the scenario of the physician dying and his wife taking over the practice. For every single day that practice is in operation in violation of the act, it's a third degree felony. So you can see how that would kind of ramp up rather quickly. If an individual has an interest in more than one clinic, AHCA may revoke the license for all of the clinics. There are administrative fines of up to $5,000 per day. and the potential recoupment of claims made to third-party payers. And it's not really the potential recoupment, it's going to happen. So some final things to keep in mind. Some health professions prohibit ownership by anyone outside of that specialty. We see this a lot with dentists. A dental practice has to be owned by a dentist. You cannot bring in an outside entity. There's no healthcare clinic license for it. We sometimes can work in a management contract where you have a dentist owner, but a management company comes in and handles most of the administrative functions. But for the most part, dentists, optometrists, and chiropractors have to own their own practices. This seems kind of obvious, but do not work at an illegal healthcare clinic. You can check the Secretary of State's website to identify the business entity that actually owns the practice. That'll tell you whether or not that individual is a exempt individual or if, in fact, they are in violation of the Healthcare Clinic Act. Identify the office's directors, managers, and members, and check to see if they are exempt. If they're not, you can inquire with AHCA as to the existence of a healthcare clinic license. It's pretty simple. If you go to the Agency for Healthcare Administration website, there's a facility license check screen. You can pull up, they actually have a block for healthcare clinic licenses or exempt facilities. So you can run the facility's name rather quickly or the owners of that facility. And inquire with the managers, officers, or owners as to the identity of all the owners. So if you need to inquire as to whether or not there are what we would call silent partners, because that can make a facility or a clinic illegal really quickly.
And because it has criminal sanctions associated with it, the police and law enforcement always have, the accessory to and concealing charges that they can bring against you if you know about it. And even if you just work there, if you know about it and you contribute to it, and you don't do anything about it, then they don't prosecute often, but it's there. So the Stark Law is a federal law. It's a physician self-referral law. It's had a number of iterations over the years, several different amendments kind of changing it and expanding it and reworking it. And it's one of the main tools that's used by the federal government to combat fraud in healthcare. So essentially what it boils down to is a physician is prohibited from referring to an entity in which he or she has a non-exempt financial interest. So what non-exempt basically means is that there's exceptions like any other good federal law. There's a laundry list of exceptions that you can, some people call them safe harbors, but that's pretty much what it is. So it's also a two-way street. So it goes both ways. So what the provider who's receiving the referral also is prohibited from accepting it. So it's a false claim for the person receiving it. So if you're making referrals to a business entity that you have an interest in, and that even if it's a small minority interest, all of the claims that business is billing out that are in violation of the Stark are subject to recoupment from the federal government. So these are, the Stark Law prohibits referrals to entities for what they call designated health services. So it's not just any kind of referral whatsoever. There's specific things. And basically these areas are identified by the legislature as ones that are particularly prone to abuse, and so they want to make sure to keep a close eye on them. Some of the really common ones are clinical laboratory services. That first one actually should be physical, I apologize. Physical, occupational, speech, and language pathology services. Radiology and diagnostic imaging is another really big one. DME is huge. P&E, nutrition, is not as big, but it's out there. Home health is another big one. Prescription drugs especially. And inpatient and outpatient hospital services are, you see that more from the hospital end, so not quite as much with individual physician practices. It's more the hospitals making improper referrals. So some real life examples, you probably have, if any of you get the kind of healthcare compliance email blasts and healthcare news email blasts like I do, this Tuomey Hospital was basically, as most hospitals do, I don't know if a lot of you are familiar with kind of how hospitals work, but there's two ways hospitals will operate with their physicians. They'll have employed physicians who are actually ones who work for the hospital, and then there'll be exclusive contract arrangements where a particular department of the hospital will make a contractual arrangement with a group of specialty providers to come in and provide the services to the hospital. So the hospital gets their technical component for the facility use, and then the physicians will typically bill for their professional component for the services they provide. So what happened here is that Tuomey, they brought in a group of physicians, and as part of their compensation structure, they received a bonus for net collections. And this was collections on both the professional and the technical component. So after much litigation, the problem was that they were getting a percentage of the profits the hospital derived from the technical part of the procedure, so the equipment usage that the physicians had no part in. So for example, if it was, I can't remember if they were oncologists or not, I think they may have been, but if there's a referral for a radiation or a chemotherapy treatment or something like that at the cancer center, the hospital is performing that with its own staff, and it's getting paid for the drugs and all of that. So the physician had nothing to do with it other than the referral, but they were getting a percentage of it as part of their bonus structure. So this one actually went all the way to a jury trial. With these Stark cases, you usually just see, once you get through the discovery phase, the government pretty much has, and the government's not going to take the case unless they've got a really good shot at it. So usually by the time you get down there, they've got enough evidence to bury them. But Tuomey fought it all the way to a jury, and it was a pretty substantial sum of money that they were able to recoup. The biggest thing is Stark violations are violations of the False Claims Act, which carry some pretty hefty penalties. Triple damages, fines for each individual claim. So if you have one false claim, you can pay triple the amount back, and on top of that, there's a fine for that each claim. So when you get these big hospital systems that are billing, and any of you who do billing and coding, each code is a claim. So it's thousands of claims times, I can't remember, I think it's up to $10,000 per claim. So the federal government can show up and they can give you numbers into the hundreds of millions of dollars that they're trying to get from you. In this case, it was $350 million that there was potential liability. So some real-life examples. A physician practice owns a DME provider and refers its patients to the DME company for supplies and equipment. This is a really common arrangement that people come in and they ask us about. They want to get it set up. So as a show of hands, does anybody know whether this is going to be compliant or not? All right. So no lawyers out there, because the answer is always it depends, right? So as it's described, this is a Stark violation because the physician has a financial interest in the DME company and he's in a position to influence referrals. So, and that's kind of the tagline. The OIG's office, the Office of the Inspector General, will issue opinions pretty frequently, usually a few dozen a year, where someone will send in a proposed transaction, and it will they'll take the names of the providers out of it, and they'll say, kind of give a summary of the arrangement that was proposed, and they'll say whether or not they think it violates the referrals. The question is it okay if the physician makes a referral, or rather makes a disclosure that they have a financial interest? And that's part of it being compliant. So that's something that you're going to have to do, but that alone isn't enough to insulate it. The trick there is if you have, there's kind of two ways to do it, and I'll talk briefly about it when we get to the exceptions, but if you have a DME company that's completely in-house, it's solely for the use of the physician practice, that you can make referrals to, as long as, and a disclosure would be part of that. And that's basically just to obviously tell the patient that the doctor has a financial interest in it, and if you want to get your DME or whatever the particular thing is somewhere else, you're welcome to do that. And you actually, I can't remember the number, but you have to have a certain number of other providers listed in the area as alternatives that they can go to. So we talked about some of the consequences. Obviously, there's the first one, the big one, is denial of the claim. And this, it doesn't matter whether it was knowing or accidental or not. It's if it's determined to be a Stark law violation, there's recoupment. There's a civil penalty that's available for the federal government, and a knowing violation can subject you to criminal liability under the Federal False Claims Act. So if you know or or should have known, or kind of were reckless as to whether or not the arrangement was legal, they can actually get you with criminal sanctions.
One thing to add to the Stark law is that if you have a cash paying practice, that they only take cash patients, Stark does not apply and a kickback does not apply. These only apply to federal claims.
Yeah, the federal laws, that's an important distinction, are specifically to federal payers. So Medicare, Medicaid, TRICARE, those kinds of payers. And I promised exceptions. There's far too many exceptions to list with Stark, but some of the major ones, there are the in-office ancillary services exception, which is what I was talking about with DME. It also applies to in-house pharmacies, any other kind of in-house imaging, things like that. So if those companies or those services are provided by the practice itself, actually in the building, and they get super technical with what counts as in the building. So you can't even have two separate suites where the patient has to walk out and go in a second door. That's not in the practice. So there has to be an internal passageway that's through a patient accessible area. So it's not like a secret door in the broom closet or anything like that. It has to be readily able to move. And they may even have, I'd have to look again, but there are cases about whether or not doors are permitted, if it has to be an open hallway. But from an accounting perspective, if people want to get a separate entity that does their DME, that entity needs to be wholly owned by the practice itself, not by one of the physicians in the practice. That's not going to be compliant. And that's the same with any of these other ones, any of the other types of pharmacy or something like that. And the other one is a group practice exception. Referrals to, if you have a multi-specialty practice, I have generals and podiatrists and things like that. If you make a referral to those other physicians, you all basically share the same revenue pool at the end. Being bonused off of referrals in that case are okay, provided that it's subject to a written contract and it's not based on the volume of value of referrals.
So moving on to the Anti-Kickback Statute, the one thing that's important to note about Anti-Kickback versus the Stark law, Stark is a civil, carries civil penalties with it, whereas Anti-Kickback is a criminal statute. So a violation of Anti-Kickback can result in significant sanctions against you or jail time. Under the Anti-Kickback Statute, it is illegal to knowingly or willfully offer, pay, solicit, or receive remuneration directly or indirectly in cash or in kind in exchange for referring an individual or furnishing or arranging for a good of service for which payment may be made by a federal health care program. So you cannot pay for referrals. And that includes offering gifts or exchanging goods for those referrals. So some kickback problem areas. One is with bundled discounts, where you supply one good or service without charge or at a reduced rate in exchange for the purchase of a different good or service. Another issue is with product support reimbursement. Manufacturers may offer free products or support in exchange for reimbursement and in exchange for those referrals. Free supplies or equipment. Manufacturers often offer free supplies and equipment. The waiving of copays. This is a definite concern because not only may you have an anti-kickback issue, but if you're waiving copays, you may have a false claim.
And Medicare, when you're talking about Medicare and waiving copays, if the service costs $100 and the patient has a $20 copay, really the service costs $80. So when that's the value of the service is $80. So when Medicare is paying you based on a percentage, if whatever the patient's plan is, if it's 80-20, then Medicare really only owes 80% of $80, not 80% of the $100 when you start waiving it. So that can cause billing issues for you there.
Another problem area is offering transportation to appointments. We have read cases and seen cases where you have a clinic or a practice that goes and takes a bus and picks up a number of people off the street and brings them into the clinic and provides services to them and then bills Medicare or Medicaid. That is a definite issue, and it is a violation of the Anti-Kickback Statute. And also offering free or reduced price medications. So one real life example, the Health Alliance of Greater Cincinnati and the Christ Hospital in Ohio were accused of illegally paying physicians in exchange for referring cardiac patients to the Christ Hospital, a former member hospital of the Health Alliance of Greater Cincinnati. A key TAM lawsuit was brought forth alleging the Christ Hospital limited the opportunity to work at the Heart Station, a center where patients receive non-invasive procedures such as stress tests, to those cardiologists who referred cardiac business to the Christ Hospital. The suit also alleged that cardiologists were rewarded with a percentage of time at the Heart Station based on their contributions to the hospital's yearly gross revenues, and these physicians earned additional income for treating patients at the facility. The result was the government claimed the Christ Hospital's use of the Heart Station panel time to induce lucrative cardiac referrals violated the federal Anti-Kickback Statute. The claims submitted to Medicare and Medicaid violated the False Claims Act, and the two hospitals agreed to pay $108 million to settle the claims they violated. So there are very, very significant penalties that are associated with the Anti-Kickback Statute. Some of the consequences: it is considered a felony for anyone who receives a form of payment in return for referring a patient for Medicare, Medicaid, or third-party coverage. There is imprisonment up to 5 years. This is the big difference from the Stark Law. There is actual jail time that's possible. Exclusion from Medicare, Medicaid. This is a death sentence for any healthcare provider. If you're excluded from Medicare, you likely are never going to work in a hospital or a facility that takes Medicare again. And possible fine up to $25,000 for each violation.
And Medicare exclusion is not just limited to licensed providers. So anybody can get on the Medicare exclusion list. So, office managers, nursing assistants, whoever's billers, they can all get on it. And once you're on that list, then you can't work, like Chris said, in a hospital, because they're required to do a background screen, and they'll get you, and they'll find out, and you can't work. And there's also there's a federal debarred list, which is a debarred contractor which prohibits you from working anywhere that gets government funds. So that can get you all the way down. The example we always use is you couldn't end up being a janitor or working the lunch line at the local high school because they get federal dollars. So you're debarred from that. So anywhere who gets any federal money at all, you can't work there.
And to elaborate on that further, if we have any office managers here, I would go back to your practice and check that debarred list and the Medicare exclusion list and make sure that none of your employees are on it. Because if they happen to be and you're billing Medicare, you potentially could be subject to some significant sanctions and recoupment of any claims that you've submitted. So like the Stark Law, Anti-Kickback also has some exceptions or safe harbors. These include investments in certain entities, space and equipment rental agreements, personal services or management contracts, the sales of practices, employment relationships, group purchasing arrangements, health plans and managed care plans, and warranties. I think a clear example of this is where you have a group practice, say a large hospital system. That hospital system is going to require physicians to refer their patients to the hospital system because they have a relationship there. They may receive a bonus, like with Stark, but because you have a group practice and you have a personal service there, it's going to fall into an exception.
Yeah, the personal services is really the biggest one here, because that's pretty much how every physician gets paid. So you have all these contracts where there's RVUs, WRVUs, patient or physicians are getting paid a percentage of their collections, and as long as that's subject to a written contract and the actual dollar amount and everything is set up front and it doesn't fluctuate based on the value of the referrals, that's a bona fide arrangement that's permitted, so that physicians can get paid for what they do.
So one of the safe harbors we spoke of was space rental. Anti-Kickback law forbids certain leasing agreements, except if the lease is for a duration of 1 year. Rent does not reflect the volume or value of referrals. The lease is not for space more than necessary. Rent is at fair market value, and the lease is in writing.
One of the common things that we see is, a lot of businesses are on revenue-based leases. So, in like shopping malls and things like that, your lease payment is based on how much, your collections. And you just can't do that in healthcare. That's one of the things to keep in mind, is a lot of arrangements, especially when you get business people who come from outside healthcare into healthcare, and they look to apply some of the tried and true things that they know. A lot of them are prohibited, so it's really important to pay attention to the regulatory scheme.
Equipment rentals. Offices find it more than economical to rent rather than own their equipment. I know with medical practices, the equipment that you need, it can be very, very expensive. But the same conditions apply as the space rental leases. And then the big one is personal services management contracts. So payment made to agents as compensation is permissible so long as the agency agreement covers all services the agent will provide, cannot reflect the volume or value of referrals, is set out in writing, not less than 1 year, and is fair market value. This is very important. If you have an employment agreement, let's say with an associate physician, you need to make sure that the agreement covers these 5 mandates. Again, it must be set out in writing and not less than 1 year.
Fair market value, although it's here, it really applies to everything, all of the things for the anti-kickback. With physicians, it's a little bit easier because you can kind of do an informal survey in the area, find out what physicians in a particular specialty are getting paid. I think the AMA actually has some statistics on their website that you can look at what average wages are. And if you have a physician who comes in and they're Harvard educated and did all of these fellowships and has lots of research and things like that under their belt, I mean, they're worth more, so you can pay them more. You're not locked into what the average is, but it just needs to be reasonable. So when you look at what's written on the paper, you just decide, somebody who is trying to convict me of something, is this going to be reasonable to them? And you just kind of use that as your guide.
Referral services. Payments can be made to a referral service if it doesn't reflect the volume or value of referrals. No restrictions on the manner in which the services referred are provided, and disclosures are made and written down.
Kind of following along with that, if you have a marketing company that's going to do practice building or something like that, comes in, offers practice building services, as long as you usually can't get away with a percentage of collections for them, because that incentivizes them to they're getting paid based, the more business they bring into you, the more that they're going to get paid. So that incentivizes them to do things that aren't above board. So when you have marketing companies, usually fixed fees are the best. A la carte services are great. If the management company, we're going to do your print advertising, it costs this much. We're going to do your web advertising, it costs this much. We're going to do in-person events or whatever it is, whatever you're paying your marketing company, or you have a marketing person, you pay them a salary. That's usually the best way to do it.
The next safe harbor here are payments made to employees. So payments made to an employee will be safe so long as there is a real employment relationship and the payments do not take into account the value or volume of referrals for Medicare or Medicaid services. So another safe harbor is recruitment, and then we'll move on to Baby Stark, which is Florida Self-Referral Act.
It's very similar to the federal one, but there are two or a couple of major differences. The investment interest is defined differently in state law, so an arrangement that may be compliant under federal or may be compliant under Florida law are not necessarily going to be the same, so you just have to look at the definitions in the statutes. Florida law also applies to all payers, not just federal. So normally where you wouldn't be in violation of the Stark law because you're taking cash patients or private insurance companies, it now is covered by Florida state law. And there's the same kind of disciplinary scheme. Licensure discipline is definitely there for physicians and civil penalties. And then.
Just to further elaborate on what Lance said, I think it's important to note that while you have Stark law in place, Florida self-referral is more strict. It applies to all services. It does not just apply to designated health services. The Florida Patient Brokering Act is Florida's version of the Anti-Kickback Statute. The key difference to remember is that it applies to all payer sources. This means that an arrangement that would be okay under federal law may be illegal in Florida. Keep in mind when trying to adopt business models from other states as well. So if you're seeing cash paying patients, you still can't pay for referrals.
So the last one we wanted to get into is the HIPAA and FIPA, which is the Florida Information Protection Act. This just went into effect in July of this year, and it's kind of a state version of HIPAA. We call it the Target Law because it really stemmed from the Target data breach from last year. So the law requires you to take reasonable measures to protect and secure personal information that's held in electronic form, to notify the Department of Legal Affairs of certain data security breaches, which would be the HIPAA equivalent would be to notify the OIG. You've got to provide notice to the affected individuals and to make sure that you properly dispose of the records. FIPA protects consumers by requiring certain entities to take reasonable measures to protect and secure data in electronic format. So it sounds a lot like HIPAA, but it's a lot more broad-reaching than HIPAA. So basically anybody, really anybody to be quite honest, can be subject to FIPA. So businesses and government agencies that acquire, maintain, store, or use the personal information of a consumer. So, and personal information has a pretty broad definition under the statute. There's obviously the medical history, medical records, and things like that. The biggest one are partial names, which means first name, last name, initials, those kinds of things that are held in conjunction with Social Security numbers, driver's license numbers, other similar IDs, you know, state or government issued IDs, passports, that kind of stuff. Financial account numbers, so anybody, that means credit and debit card numbers. So that's pretty much everybody, unless you are, you know, a street vendor or something like that only take cash. You know, if you have anywhere there where you've got credit or debit card numbers stored, you know, in your credit card machine or in a database for billing or anything like that, you're subject to the law. Another one, health insurance policy numbers. So if you have their policy numbers or a patient ID number or something like that, all of that counts as personal information. And then username and password. So if you have a username and password that allows access to an online account, and that doesn't have to be a financial account, just any kind of online account. And the big thing to keep in mind is the harm that's going to come to the person. So you know, if you have an online account that's for like their newspaper subscription or something like that, it's probably not going to be an issue. But if the information that's stored in that account can be used in a way that can harm somebody, then you know, consider that as being subject to the law. The breaches are also very different. As you can see just from the length of the definition, HIPAA is very specific. So all of these are defined terms: acquisition, access, use, disclosure, protected health information, compromises the security or privacy of protected health information. Those are all defined terms in the federal statutes. They have a very specific meaning. Here under FIPA, it's just unauthorized access of data in electronic form containing personal information. Personal information is the only defined term. Unauthorized access pretty much has just a general meaning. So whatever means if they weren't supposed to have it and they got it, that's unauthorized access. Data security, so they have to take reasonable measures to protect and secure the data. So it's a pretty broad standard. So reasonable is, and it's written that way to specifically take into account, the legislature wasn't interested in deciding what 128-bit encryption, 64-bit encryption, whatever it is, they're not interested in that. So what reasonable means is whatever's reasonable in the industry. So if your computer guy tells you that 128-bit encryption or whatever the next step is what you need to have, if that's what's being done in the industry, that's what you need to have. So it's expensive, or those kinds of defenses just aren't going to be there anymore. And with the sophistication of computer hackers and you know all of this talk about the Chinese government getting groups of hackers together to hack American healthcare companies to try and pull that information and those kinds of things, it's really important, especially being in the healthcare field. You know, our records are going to have patient information. They're going to have credit card billing information. There may be photocopies of checks that have routing numbers, bank account numbers on them. social security numbers. Pretty much everything that was on that list under FIPA is something that a medical practice is going to have. So it's really important that you make sure that your data is secure. Digitize whatever you can that you've got on paper and get rid of the paper so that it can't walk out the door. All of those kinds of things are what we really need to be paying attention to. We kind of talked about all this. So ensuring compliance is the biggest thing. Whatever we're talking about, self-audits are invaluable. Just whatever you need to do, just weekly, monthly, whatever makes sense. Have somebody pull claims aside, look at your contracts, just look at what's laying around the office. Just kind of simple. Just keep your eye out as you walk around. If you see patient information stuck in the corner somewhere, or a sheet falls out, or somebody's throwing something in the trash that should have been shredded, just pay attention to that kind of stuff.
One thing that's important to note is that if you have data that's in an electronic format, make sure that it's encrypted. And by encrypted, we don't mean just have a password on it. It needs to have encryption software, and that will protect you from a possible HIPAA breach or even a FIPA breach.
One of the things that we've done in our practice, we've noticed that because we get a lot of health records, things that get scanned as a PDF into Adobe, you can put a password protect on an Adobe document, but that's not encryption. There's a separate tool in Adobe that you can use to encrypt it. So those are the kinds of things that you also need to be, just because it's digitized and it's in a password doesn't mean that that's going to be secure enough. The notice requirements for FIPA are similar to HIPAA. They have a threshold amount for a certain number, but the notice provisions are pretty strict as far as time-wise. With HIPAA, usually it's 60 days to notify OIG, or if it's a minor breach under a certain amount, you can do it annually. It's not like that under FIPA. So notices have to be provided to the consumer within 30 days, unless you show good cause as to why you didn't. They may be hard to locate or something like that. And you need to notify the Attorney General for a breach affecting 500 or more individuals. And that, I don't have it here, but I think that's also within 30 days. The breach also defines what information, the definition rather in the statute defines what information you have to be included in a notice. So the statute gives you some guidance there. And it also expands a data breach statute to include state and government entities and their contractors. So if you, I know there are a lot of practices that work with counties and local governments and things like that, you can be subject to the same requirements that the government is. And we've kind of talked about the notice. I know we're out of time, so that's what we have for you today.
Take some time for some questions. So I'm going to work the room. If you have some questions, please raise your hand and we'll get them answered. So let's start right over here. I'll hold the microphone.
The healthcare clinic, the definition of a healthcare clinic, if you are putting yourself out, like advertising, as a health and wellness clinic, which we see many in the newspapers, in the phone book, in the little flyers you drive down, and they are not owned by a physician. They're not owned by an allopathic physician. I mean, there's a number of things that you mentioned that are flaming violations, and between here and my job, I can probably see 100.
Testosterone clinics come to mind as one of those ones that a lot of people are jumping into. One of the things, and I don't remember if we mentioned it or not with the healthcare clinic license, it's contingent upon submitting claims for reimbursement is one of the other things that's in there as part of the definition. So a lot of those practices that you're talking about are cash only, cash on the barrelhead practices. The patient prepays for the services before they get them. So that allows them to be exempt. And claims for reimbursement also mean billing your patients, not just billing a third party. So it can be a two-party arrangement. If you're submitting something for remuneration to your patient, then that can get you into the healthcare clinic. So if you are strictly a cash practice, taking everything up front before services are rendered, or then that can still get you in for the exemption. That's where a lot of those places fall. And a lot of them are illegal. I can't tell you how many of them come in that are talk to us and they're illegal, so they're just waiting to be found out.
Okay. Our next question.
In the very beginning you mentioned, I have two questions for you. In the very beginning you mentioned a $39.5 million fine. Is that paid to the government, or is that reimbursed back to some people, like patients and things like that? And the other question is, I went to my doctor who's now owned by Florida Hospital. He wanted me to get an MRI, so he sent me to a Florida Hospital MRI clinic. Was that okay, or was that improper?
That's permissible. It falls under an exception, because that would be a group practice.
Because Florida Hospital owns the physician practice and they own the imaging equipment, so it's all in-house.
And the fines go to the government.
And those get parceled back out to the patients or whoever got affected in some particular way, shape, and form.
It's supposed to work that way.
Okay. All right. Next question.
Back to your example where you had the husband and wife, the husband died. It seems prudent for a practice to never leave themselves that vulnerable so that they could have a transfer. Does anybody do, like if you had a 5% owner and there was an arrangement that he would continue to see those patients even in that practice or something like that?
Well, the problem is, the reason why that exception works is because the wife is a direct relative of the physician. So if you had a 5% owner who happened to be a physician, then you're still going to be in violation of the Healthcare Clinic Act, because you're going to have a non-physician owner without a direct relationship to the other physician.
The answer is to just marry the widow. Yes.
Our next question.
Oh.
To add to his question, what are some of the remedies for those cases that you brought up where there's a business structure liability or current improper ownership combination? Is there what do you guys usually do to correct that or bring it in compliance?
Well, if a healthcare clinic license is required, you immediately have to get that application in. And we put our clients on notice that they may be liable for recoupment of all the claims they submitted between the date the violation occurred and the date we get that application in and approved.
But the other thing that we'll do is if clients come in and you have a physician or you have an exempt person and a non-exempt person as partners, if the operating agreement or will allow it, we'll do an immediate corporate resolution to expel the non-exempt owner because they're making the business operate illegally, and that may subject you to some litigation, but that's usually better than felony counts for every day that it's open.
Okay, our next question's here. I'll make it to that side of the room, I promise.
Yes, thank you very much, as good as always. Two questions. Billing services and collection services often charge a percentage of what is collected. Is that okay? That's the first question. Second question is, when you have a HIPAA business associated agreement with a provider, does that need to be updated to include the Florida Information Protection Act?
Yes and yes. The business associate agreements need to be updated with the Florida Information Protection Act information, and the billing is okay because the billing company is not in a position to influence the referrals. The billing company is just providing a service, so they're really getting paid on an a la carte basis. They're being paid per claim for a task that they perform, so they can't do anything like that.
Okay, question over here.
Hello, I got two questions. The first question is what would you say a practice needs to ask their healthcare IT company that they work with? Because my concern is if they're HIPAA compliant, plus if they're what their beliefs are, the use of encryption, because I have many concerns in that area. Second question is, on the first part of your presentation, if it's around an ACO, what % of all of that matters? So,
with the ACO, the answer is precisely 0. So ACOs have an exemption built into them, or the Affordable Care Act and the creation of the ACOs basically exempt all of those other things from the arrangements. And there's provisions in the Florida equivalent laws that say if it's compliant under the federal government, under the federal scheme, then it's compliant under Florida law. So it hasn't been tested in court yet, but that's pretty much the opinion of most healthcare attorneys and people who deal with ACOs like I do. That's kind of where everybody thinks. If the federal government says it's okay, then Florida doesn't have anything to complain about.
Is there any requirements that the practice should go back and look at their healthcare IT company to make sure they're covered? That, especially again with the law that just came out in July, my concern is they're not covered. They don't have the right IT company in there that is HIPAA compliant, that their BAA is not legitimate what it should be, that the healthcare IT company doesn't have them set up properly with encryption, that sort of thing. What would you, is there a checklist somewhere, or is there something that you advise your clients to ask their healthcare IT vendor?
Well, I think the first step is to get the policies of the IT company and make sure that they are in fact aware that FIPA is out there. Because these companies have been established to comply with HIPAA, but I think HIPAA is kind of a new animal, and it's far more broad than HIPAA, as Lance was talking about. And most of the BAAs that you have are going to be HIPAA compliant, or they should be HIPAA compliant. But they need to address the FIPA statute. And I think if it says that it addresses FIPA and it has the FIPA definition within it, that probably will be enough.
Yeah, I think that's right. One thing that contact your healthcare IT provider and ask them if all of your data is encrypted. So get yourself a copy of the FIPA statute, look at what counts as personal information there, determine whether or not your business has that information stored somewhere, and call your IT guy and say, are my credit card numbers protected? Are my social security numbers protected? Are all of those things protected to the same degree that the health records are? They probably are, but if you may have a computer system where you have payments separate than than the patient information, then you may need to look at that. And the same thing with your business associates, with your billing companies. There are a lot of national billing companies who probably have no idea about FIPA. And so it's probably a good idea to get a FIPA addendum to your BAA. Contact our office can do that. Where find somebody who can help you to make sure that it's compliant. And a lot of people don't know about it, but there's data breach insurance. It's not very expensive. It's a great idea to have because most of these companies who you have your IT through, that EMR companies, the damages you can collect from them if they screw up are limited to the cost of the contract. So if you're paying them $50,000 and they subject you to an $11 million HIPAA fine, they're on the hook for 50 grand and that's it. That's what the contract says. So you can get data breach insurance that'll cover those kinds of the fines and losses associated with the data breach.
Right. Question right here.
Well, I guess this is kind of a little bit of a follow-up to what you just said. We do have an existing business associates agreement with a healthcare company that's headquartered in another state, but they have facilities here in Florida that we work with. Should we be, as a an internet vendor, go to them and say, hey, are you aware of this FIPA and can we get this addendum attached to it? Is it better that we kind of take that forefront of, hey, we know what's going on and outreach to them versus waiting for them to provide that paperwork to us?
Well, I think you have to be proactive because if you wait for them, it's never going to happen. Because the FIPA is so new that there haven't been any issues. There haven't been any breaches related to FIPA. It's 2 months old, so we've got time to.
Yeah, I mean, if you have if you have a breach on the first day the law was active with the 15-day extension, we're kind of right at 45 days. There actually hasn't even been time for somebody to make a report yet. And the other thing is that as someone's business associate under FIPA, you're subject to FIPA as well. So waiting on somebody else to handle your regulatory burden is not going to do you any good.
And you can use that as a differentiator between you and the other web companies anyways, that you are truly HIPAA, FIPA compliant.
Long question. I think everyone would agree that a business person, an MBA, would be incompetent to perform healthcare procedures. I would also think that people would agree that a medical doctor, a person with a degree, education in healthcare, would not be skilled or trained in running a business. But apparently there's a law that requires that a physician, only a physician can own a medical practice. Yet that not only flies in the face of common sense, it also leads to competition between that practice and a group like Florida Hospital that can operate with business people, putting, I would think, that physician group at a competitive disadvantage. Is there any thoughts about trying to change that law?
we're not going to be able to change the Healthcare Clinic Act just because of the amount of fraud that was rampant throughout Florida throughout the early 2000s. That's what the Healthcare Clinic Act was established to prevent. And I just don't see our current legislature or future legislatures rescinding that.
And I don't know that it's necessarily a competitive disadvantage if you comply with the regulatory scheme, because you can bring a business person in who can open, they just have to get the license. A hospital can't just open its doors too. So a hospital has arguably more regulations that it's subject to than a physician practice or a licensed healthcare clinic. So business people are free to do that. There's just a couple of hoops and probably 4 to 6 months worth of lead time to get the business set up, but there's nothing to stop them from doing that.
And the Healthcare Clinic Act doesn't prevent non-physician owners from being an owner of a medical practice. It just makes it a little bit more onerous. The application process is difficult, it's expensive, but you can have a non-physician owner.
Great. Question over here.
What do you tell your clients who own a medical practice? What is your policy for their employees who use their facilities to surf the web or do personal things on the computer systems in the office that might expose that practice to threats beyond the antivirus and the types of protections that the office might have in place?
I mean, that's difficult. There are some programs that you can put in place that prevent individuals from surfing certain websites. I know our firm has a policy that you aren't really allowed to download anything onto your computer. Only the administrator can. And it's to protect our clients' files and our businesses' files. So I think if you have a policy in place that does that, that's the first step. But I don't know if in this day and age with the complex programs that are out there and the spam emails that everybody gets, I don't know if you're ever going to adequately protect your server and your files from that type of invasive activity.
Chris hit on it, a real simple thing that you can do if you're kind of computer savvy yourself, or if you have an IT guy who can come in and you can set up a separate profile on the computer. You have an admin profile that you maintain the password, or your trusted office person does, that will allow downloads and things like that. And then you have a user one that the office people your regular workers will come in, and that's what they'll type in, and that has no administrator access to the computer whatsoever. They can't download anything without a password. And while there are going to be viruses and things out there that can circumvent that, it's going to make it much, much easier for them to be compliant. And then you don't like it, but you can just put internet blocks up. You can just block websites.
Well, great. Gentlemen, thank you so much. Let's give it up for Christopher Brown, Lance Leader. We really enjoy having you here each time.